All right. Good afternoon, everyone, and thank you for joining us today. My name is Janae Morrissey, and I work in the Office of Non-Public Education, or ONPE, at the U.S. Department of Education. I'll tell you just a bit more about ONPE in just a moment, but first I would like to introduce my colleagues. Joining us from the Office of the General Counsel, or OGC, is Mike Anderson. From the Office of Elementary and Secondary Education, or OESE, is ADL Duran. And then also from the Office of Non-Public Education, Isadora Binder. Isadora and I are the primary points of contact in ONPE for Title I and Title VIII equitable services, respectively, and work together to provide targeted technical assistance for ESEA state ombudsmen and others. ONPE, OESE, and OGC routinely collaborate to provide technical assistance, develop non-regulatory guidance, and respond to inquiries regarding equitable services under the ESEA, and we're happy to have another opportunity to do so here today. Now, before we get started on the presentation, just a few housekeeping notes. While your cameras and mics are disabled, the chat is open. You are welcome to submit questions. However, we may not have time to address every question. So if your question is not answered directly or by content in the presentation, please follow up with us via email following the webinar. We will give you that contact information at the end of the presentation. Also, if you are seeing or have access to the Teams Q&A app, please do not use that to submit a question. We don't actually have access to that app at this time, so we will not see any questions submitted through the Q&A feature, but you can use the chat feature. And finally, yes, we are recording this webinar. You should have seen that notice pop up for you when you joined, and we will be making this along with the slides available as soon as possible via the department's YouTube channel. Now, very quickly, I'll give you an overview of what you can expect in the webinar today. Our primary objective is to provide an overview of the key requirements for the provision of equitable services under the Elementary and Secondary Education Act. This will include both general requirements that apply across programs, as well as some requirements specific to Title I, Part A, and programs covered by Title VIII. But first, I would like to talk for just a moment about the Office of Non-Public Education, just in case you're not familiar with us or some of the work that we do. ONPE is the department's liaison office to the private school community, including independent, faith-based, and homeschools. Our mission is to maximize the participation of private school students in federal education programs, such as those authorized under the Elementary and Secondary Education Act. We provide resources, technical assistance, and participate in the development of regulations and guidance related to federal education programs. And one of ONPE's many resources for private and homeschools is the ONPE website pictured on this slide. We encourage you to visit and explore our website where you'll find valuable information, guidance, and resources that will assist you as you implement equitable services for private school students and teachers. The easiest way to get there is to head over to ed.gov and enter the Office of Non-Public Education in the search bar at the top right of the screen. And we can also drop that link in the chat as well, so you have easy access. In addition, we invite you to sign up for the ONPE listserv, which is the first link at the top of the additional info box. Periodically, we disseminate information, including announcements about new initiatives, updated guidance, or even webinars like this one. Also, in the additional info box, you'll see links to the ESEA Title VIII Equitable Services Non-Regulatory Guidance and the updated Title I Part A Equitable Services Non-Regulatory Guidance, among a few other items we've placed there for easy access. And I believe links to those documents will also be dropped in the chat for you. Now, I will get us started with a quick introduction to the ESEA Equitable Services requirements. By way of background, since 1965, the Elementary and Secondary Education Act has required local educational agencies, LEAs, and other eligible entities to provide equitable services to students enrolled in nonprofit private schools, their teachers, other educational personnel, and in some cases, families in a number of ESEA programs. This was based on the child benefit principle, meaning that a child who met the eligibility requirements could receive services regardless of the school the child attended. It's important to note that, like their public school counterparts, private school students generate some of the federal education program funds that are allocated to states and LEAs. The ESEA requires participating LEAs in consultation with appropriate private school officials to provide eligible children attending private nonprofit elementary and secondary schools, their teachers, and in some cases their families, with services or other benefits that are equitable to those provided to eligible public school children, their teachers, and their families. Now, the Title I equitable services provisions are found in Section 1117 of the ESEA. The purpose of Title I is to provide all children a significant opportunity to receive a fair, equitable, and high-quality education and to close educational achievement gaps. For that reason, Title I equitable services are focused on children who reside in Title I attendance areas and are failing or most at risk of failing. This necessitates a few significant differences in the provision of equitable services under Title I versus programs covered by Title VIII. Our presentation today will provide an overview of those differences as well as the similarities. Now, under the ESEA, the Title VIII equitable services provisions cover the following programs: Title I Part C, Title II Part A, Title III Part A, Title IV Part A, Title IV Part B, and Title IV Part F, which is Project Serve. As noted on the previous slide, Title I has its own equitable services provisions. And in contrast to Title I that limits eligibility based on residency in a participating public school attendance area within a specific LEA, eligibility for programs under Title VIII is not based on residency. Rather, students enrolled in private schools located within the LEA are eligible to receive services regardless of where they may reside. So, however, under Title VIII, some programs do restrict eligibility or participation to a particular group of students, in which case the eligibility or participation of private school students likewise is restricted. And the best example of that would be for Title III Part A for English language acquisition. I will now turn it over to Isadora to review the requirements of timely and meaningful consultation.
Thank you, Janae. So let's get started. LEAs are required to consult with private school officials regarding the provision of equitable services. The consultation between public and private school officials should be timely and meaningful and result in services designed to meet the educational needs of eligible private school students and teachers. Consultation must include meetings between LEA officials and private school officials and occur before LEA officials make any decisions that affect the opportunity for private school students and teachers to participate. In addition, consultation must occur during the design, development, and implementation of the respective programs. While the LEA does not define any specific requirements of private school officials in the consultation process, private school officials can support the consultation process by providing the LEA the names of the private school officials who should be included in the consultation process, along with their roles and levels of authority. In addition, private school officials can provide information about the needs of their students and teachers and suggestions for the LEA to consider regarding how such needs might be met through program services. Timely and meaningful consultation is essential to effective implementation of equitable services. The obligation to initiate the consultation process lies with the LEA responsible for providing equitable services to all nonprofit private schools that enroll students that reside in the LEA's Title I attendance areas for Title I or in the LEA's geographic service area for Title VIII. The LEA should contact private school officials on an annual basis. LEAs initiate this often through an intent to participate form, which provides information about the services available, and if known, the amount of funds or estimated amount available for those services. This allows private school officials an opportunity to make an informed choice upfront about whether or not they would like their students and teachers to receive services. The LEA can then move forward with a more focused consultation with those schools that do wish to participate. Meaningful consultation provides a genuine opportunity for all parties to express their views, to have their views seriously considered, and to discuss viable options for ensuring equitable services participation of private school students and educators. Timely consultation provides adequate notice to help ensure that those involved will be well prepared with the necessary information and data for decision making. Successful consultation establishes positive and productive working relationships, making planning effective, and serves to ensure that the services provided meet the needs of eligible students. It is important to remember that LEA officials make the final decisions regarding the provision of services after consultation has occurred. However, an offer of services by an LEA without an opportunity for timely and meaningful consultation with private school officials does not meet the requirements of the law. Only after discussing key consultation issues relating to the program and provision of services does an LEA make its final decisions with respect to the services it will provide to private school students. The LEA must provide evidence of agreement to Ombudsman. The ESEA requires that the LEA discuss the following topics in consultation for both Title I and Title VIII covered programs: how children's needs will be assessed or identified, what services will be offered, how, where, when, and by whom the services will be provided, how services will be assessed, and how the results of assessment will be used to improve services, the size and scope of the equitable services to be provided, which includes the amount of funds available for those services and how that amount is determined, how and when the LEA will make decisions about the delivery of services, whether the LEA shall provide services directly or through a separate government agency, consortium, or entity, or through a third-party contractor, and where there is disagreement on this topic, the LEA is to provide a written explanation of the reasons they have chosen not to use a contractor. Whether to provide services by creating a pool or pools of funds, or on a school-by-school basis, and whether to consolidate and use funds for equitable services under Title I in coordination with equitable services funds for Title VIII covered programs. An additional consultation requirement for Title I is the method or sources of data that are used under subsection C and section 1113C1 to determine the number of children from low-income families in participating Title I public school attendance areas who attend private schools. Consultation is an ongoing process, not a one-time meeting. Initial consultations should occur before the LEA makes any decision that affects the opportunities of eligible private school children, teachers, or other education personnel to participate in a covered ESEA program and should continue throughout the implementation and assessment of services. An eligible LEA applying for a discretionary grant, such as 21st Century Community Learning Centers or Project SERVE, must consult with appropriate private school officials before the LEA makes any decision that affects the opportunities of eligible private school children and educators to participate. Essentially, consultation should begin during the development stage of an application. Prior to submitting its application, an LEA could, at a minimum, initiate consultation through a survey of private schools to ascertain private school interest in the proposed program and gather information from interested schools that will allow the entity to both consider the needs of all students and educators, both public and private, in developing its application, and to include the projected cost for equitable services in the application. If the LEA receives a grant, it must continue to consult with interested private school officials on the specific services the LEA will provide students and educators. For more detail on equitable services under these programs, you may review the Title VIII Equitable Services Non-Regulatory Guidance Sections K and L. Each LEA shall maintain in the agency's records and provide to the state educational agency involved a written affirmation signed by officials of each participating private school that the meaningful consultation has occurred. The written affirmation shall provide the option for private school officials to indicate such officials' belief that timely and meaningful consultation has not occurred, or that the program design is not equitable with respect to eligible private school children. If private school officials do not provide an affirmation within a reasonable period of time, the LEA shall forward documentation that consultation has, or attempts at consultation have taken place. The written affirmation may incorporate documentation of agreement. LEAs should consult with private school officials on the development of a consultation timeline to ensure that all parties will be available and ready to participate fully in order to ensure timely delivery of ESEA equitable services. This slide provides a sample timeline that may be helpful as LEAs and private school officials develop their own timelines for consultation. Some actions listed here may need to occur earlier, depending on specific circumstances. The chart also only lists specific actions that would occur at different points throughout the year, but keep in mind that the provision of services is ongoing and there may be a need for additional consultation at any given time for current equitable services. The ESEA requires an LEA to consult with private school officials regarding the size and scope of the equitable services to be provided, the proportion of funds that is allocated for equitable services, and how that proportion is determined. Given that consultation must occur well before allocations are finalized, it is likely that the initial discussions of this topic will be based on estimated allocations for the coming school year, which may be based on the prior year's allocations or preliminary allocations for the coming school year. At this point, I'm going to turn it over to Mike Anderson for a discussion on allocations and other fiscal considerations.
Thanks, Isadora. And as Janae mentioned at the outset of this presentation, I am in the Office of the General Counsel, and I've been working on equitable services issues now for well in excess of 10 years, and happy to provide some insight on some of the issues related to allocations, as well as some other fiscal considerations. Now, consultation is really the foundation of equitable services, but determining the funding available to provide equitable services is no doubt also an extremely important aspect of equitable services. As with a lot of things involving money, as I'm sure we can all relate to, it also can be the most contentious part of equitable services. Hopefully I can shed a little bit of light on the overall process so that it goes as smoothly as possible. Please note that the way equitable services funding is determined is different for Title I and programs governed by Title VIII. The next several slides will give a general overview of determining an equitable share under both. I'll then touch on a few other fiscal considerations involved in providing equitable services. I'll start with the process for determining funding for Title I equitable services, what we generally refer to as the proportional share. As a general rule, an LEA must determine the proportional share based on the proportion of children from low-income families who reside in participating Title I public school attendance areas and attend private schools. It's not sufficient for a child to be from a low-income family. Rather, they also must reside in a Title I public school attendance area. Another important principle for Title I is that the calculation must be based on the total amount of Title I funds received by an LEA. So this means that an LEA must base the calculations on its entire allocation, including any funds the LEA transfers into Title I from other programs, such as Title II, before it expends any funds or reserves any funds for other required or permissible purposes, including administration, parent and family engagement, children in local neglected and delinquent institutions, homeless children, and any other district-wide initiatives that the LEA might have. For example, if an LEA's total allocation is $1 million and the proportional share is 10%, the LEA would need to reserve $100,000 for equitable services, basing that amount on the entire amount of the allocation. Of course, to calculate the proportional share, an LEA first must determine the number of children from low-income families that attend private schools and, again, reside in a Title I public school attendance area. For this purpose, the ESEA authorizes 5 methods an LEA may use, either individually or in combination. And I think that's an important part. It doesn't have to be one, but you can use a combination of these methods for determining poverty counts. The most straightforward measure of poverty, if available, is to use the same measure as is used to count public school children. In practice, this usually is free and reduced price lunch data. Unfortunately, however, to use this measure, the private school would need to participate in the school lunch program, which often is not the case. So in the absence of this data, the free and reduced price lunch data that public schools generally use, an LEA can use the comparable poverty data from another available source, such as private school scholarship applications, if available, or data collected as part of the private school's participation in the FCC's E-rate program, which uses the same income threshold as free and reduced price lunch. If no existing data is available, the LEA also can conduct a survey to obtain comparable data to what is available for public school students, which I'll expand on in a moment. Another option is proportionality, where an LEA applies the same proportion of low-income children in public schools to the private school population that resides in a Title I public school attendance area. For example, if 60% of public school students are determined to be low income, then that same proportion or percentage would be applied to the number of private school kids that are in a particular public school attendance area. You would look at that on an attendance area by attendance area basis. A final option is using an equated measure, which involves determining the proportional relationship between 2 sources of data for public school students, and then applying that proportion to a known source of data for private school children. This is fairly uncommon and complex, but if you want to see an example, I encourage you to look at B11 in the Title I Equitable Services Guidance. I think in all of the years I've been working on equitable services, I don't think we've ever had a situation that I'm aware of where we've been aware of the use of an equated measure, but it's certainly an allowable measure. In terms of determining which measure or measures of poverty to use, it must be discussed in consultation. Although an LEA has final decision-making authority, it nonetheless must give due consideration to the views of private school officials with the goal of reaching agreement. One other thing to note is that, and that is sometimes overlooked, is that an LEA may determine the count every year or every 2 years. This can be useful in reducing burden, particularly if an LEA uses a survey. As I mentioned, because surveys are frequently used, I want to expand on this particular measure a bit. A couple of things to keep in mind are, first, The survey only needs to go to families of children who reside in Title I public school attendance areas, not all students in a private school. You can usually determine this by the address where they attend, the consultation with private schools will help to determine those attendance areas, which might be applicable to a particular private school. Second, the survey only needs to collect the information reflected in the numbered items on this slide. So that's verification of residence in a Title I public school attendance area, grade level and age of each child, and household income. Note that in particular, that income information should be for the household, not just parents, which is consistent with what is required for determining eligibility for free and reduced price lunch. In using a survey, if an LEA is not able to obtain complete data, it must extrapolate full results if it has obtained an otherwise representative sample. As noted in the updated Title I guidance, an LEA may proceed on the presumption that it has obtained a representative sample. If the LEA or private school officials disagree, though, the LEA and private school officials will need to engage in further consultation regarding whether the data is in fact representative. So, what happens if an LEA is not able to obtain a representative sample that enables extrapolation? Well, in this case, the LEA will need to identify other sources of data that can be used in place of or in conjunction with the survey data it does obtain. For example, if an LEA receives survey data for only 25 out of 100 children in a private school who reside in a participating Title I public school attendance area and determines that this is not representative, the LEA may count the 25 children on the completed surveys to determine, in part, the number of children from low-income families. For the remaining 75 that didn't complete the survey, the LEA could use other available poverty data. This could include E-rate or scholarship application data, or another authorized source of data, such as proportionality. You would apply that proportion just to the number of families or to students who didn't submit the survey, and you do that in conjunction with one another. To the extent that an LEA does use multiple sources of data, the LEA will need to take steps to ensure that it uses comparable income levels and that there are no duplicate counts. So here is an example of determining the proportional share for Title I once the number of children from low-income families is determined. As you can see in this example, the LEA has 4 public school attendance areas, that's A, B, C, and D, with an overall proportion of children from low-income families that is 90% public and 10% private. Thus, assuming a total allocation of $1 million for the LEA, the amount that must be used to provide equitable services is $100,000. You apply that 10% again to the total allocation. That's before any reservations or anything like that. So now let's shift to Title VIII, which thankfully is a little bit easier. This is because income data is not required. For programs covered by the Title VIII Equitable Services provisions, and Isadora went through those earlier, ESEA Section 8501A4A requires that expenditures for services to private school children and educators be equal to the expenditures for the public school students on a per pupil basis, taking into account the number and educational needs of the children to be served. Unlike Title I, which looks to a child's residence in a Title I public school attendance area, It's important to note that Title VIII focuses instead on the number of eligible children enrolled in a participating private school, regardless of where they reside. Now, many LEAs calculate equal expenditures strictly on the basis of the relative enrollment of eligible public and private school children, on the assumption that these numbers also accurately reflect the relative needs of children and educators in public and private schools. However, an LEA might choose an additional factor related to relative needs in determining equal expenditures and consider that factor for the two groups of children. One area where we've seen this come up is with Project SERVE, which provides grants for areas experiencing schools experiencing traumatic events such as school shootings. And in those cases, we're aware of instances where an LEA has applied that need factor because the school where the event actually occurred might have and frequently would have a greater need than other schools that might be more might be affected less directly. Please remember, an LEA may not base the determination solely on the factor relating to educational need, because the statute requires that both the number and educational needs of the public and private school children be taken into account. As with other decisions affecting services to private school children, an LEA must consult with private school officials on how the amount of funding for equitable services is determined. You'll note that Isadora, that was one of the things that Isadora mentioned when she was going through the consultation topics. Here's an example for determining the equitable share for Title VIII cover program. Note that in contrast to Title I, the number of eligible children enrolled in the LEA, it's determined based on the number of eligible children enrolled in the LEA as compared to private schools. Also, unlike Title I, for Title VIII covered programs, the statute does not require equitable services to be calculated prior to reservations. Thus, this example shows that the LEA has reserved funds for administrations of the program as a whole. And this is, both the public, the equitable services component, as well as the component for serving for public schools. When you're reserving that administration, it would cover both. So that leaves $950,000 upon which to determine the calculation. So applying the 10% proportion, again, based on enrollment, not residence, this results in $95,000 being available for equitable services. So the ESEA requires different forms of notice related to the amount of funding available for equitable services. At the SEA level, the ESEA requires an SEA to annually provide information on the amount of funds allocated for equitable services under Title I and for each Title VIII covered program the LEA operates. It is important to note that this notice does not require information to be broken down for each private school, but must only include the amount an LEA has allocated as a whole for each program to provide equitable services. Again, it's got to be for each program, so that's Title I, and then each program that the LEA participates in, other ESEA program that is covered by the equitable services requirements in Title VIII. Now, an SEA has flexibility to determine, in consultation with private school officials, an effective manner for disseminating and a reasonable timeline for providing the notice of allocation. An SEA may consider methods such as publicly posting this information on the SEA's website, using an email distribution list of private school officials, and other methods. To ensure that the notice is provided in a timely manner, dissemination would generally occur prior to the beginning of the school year, or at least as near as possible to the beginning of the school year. Although the ESEA notice need not include funding broken down by private school, the ESEA does require LEAs to consult regarding the proportion of funds that is allocated for services in private schools and how that proportion is determined. So the LEA would need to share this information with private school officials. Initially, LEAs generally use estimated figures. But once that final data is available, an LEA is required to provide final numbers to private school officials related to the funding of a particular school. Okay, to wrap things up regarding fiscal issues related to equitable services, I wanted to touch briefly on a few other topics besides the funding piece. Now, one of the foundational principles of equitable services is that the control of funds remains with a public agency. So under these public control of funds requirements, the control of funds and title to materials, equipment, and property purchased with those funds has to remain with the LEA. The LEA must administer such funds, as well as the material, equipment, and property. It's generally with supplies and equipment, would entail keeping an inventory and having those items marked as property of the LEA. Private school officials, or private schools that is, receive no funds under the ESEA programs. Rather, they're eligible private school students, educational personnel, and depending on the program, sometimes families receive services from LEAs. Private schools have no authority to obligate funds, nor may they receive reimbursements. It's also worth noting that LEAs may provide equitable services directly or through a contract with a third-party provider. A third-party provider, if used, must be independent of the private school itself. Another requirement to keep in mind in the fiscal arena is a requirement for an LEA to obligate funds for equitable services in the fiscal year in which they are actually received. The purpose of this requirement is to ensure that an LEA obligates the funds available for equitable services so that students, educators, and families receive services in a timely manner. Although LEAs, and not private school officials, are responsible for meeting the requirement, in some cases, the LEA might need assistance from private school officials. In these situations, an LEA may impose reasonable deadlines, subject to consultation, of course. Given the obligations of funds requirement, we often get questions about whether carryover is permitted. As a general rule, if an LEA is meeting the requirement related to obligation of funds, there shouldn't be any carryover at all, or if any, it would be a very small amount. If for any reason an LEA does not meet the requirement, however, it does not mean that the funds cannot be carried over. It's not a prohibition. In fact, the LEA generally would be required to carry over funds to otherwise carry out its equitable services. This might occur if services are delayed for unanticipated reasons. We had a lot of that come up when COVID first hit and things were shutting down, and so equitable services couldn't be provided. And so if the LEA is not able to provide all services in a timely manner, then those funds can carry over and then be used the following year above and beyond the funds that would otherwise be required to be provided for equitable services. All right, finally, I want to touch very briefly on pooling. This occurs when funds generated for service in a group of private schools are pooled or combined to focus services where there is the greatest need, irrespective of the school that generated the funds. With pooling, the LEA must develop criteria with private school officials for purposes of determining how services will be targeted. Now, pooling occurs most frequently among affiliated schools. You might have a group of Catholic schools or a group of Jewish schools, and in consultation, they work with the LEA and decide that they're going to pool all the funds generated from those by students in those schools, and then target them to the students that have the most need, irrespective of which school those students are actually attending. So it's almost like you're creating one giant school out of multiple schools and then determining where the need is most. Like other aspects of equitable services, consultation is required prior to pooling. An LEA may not make a unilateral decision to pool. In fact, consultation is particularly important with respect to pooling because it is an exception to the general rule. And that general rule requires providing services on a school-by-school basis using only the funds generated for services in that particular school. Now, given that pooling could result in reduced or even no services being provided, one or more schools that's included in a pool, an LEA and private school officials must agree to pool during consultation. And it's important to note that this is the one area of equitable services where there must be that agreement. Okay, now that we've covered the allocations and some of the other important fiscal areas, I'm going to turn this over to ADL, who's going to talk to you a little bit about delivery of equitable services. All yours, ADL.
Thanks, Mike. Good afternoon, everyone. It's a pleasure to present to you all today. I'm Adil Duran with the Title I team at the Department's Office of Elementary and Secondary Education. I'll be discussing the final two topics for this session, the delivery of equitable services and also the monitoring and enforcement of equitable services. And we'll start with student eligibility for Title I equitable services. So in general, in order to be eligible for Title I services, a private school child must reside in a participating Title I public school attendance area and also must be identified by the LEA as low achieving on the basis of multiple educationally related objective criteria. We've emphasized the residency requirement in the first bullet, and with respect to the educationally related criteria that's established for identifying eligible children for Title I services, this needs to be done in consultation with private school officials. So the LEA and private school officials should identify those private school children in greatest academic need to receive Title I services. The ESEA also allows for certain groups of children to be eligible for services solely based on the specific status listed here in the second bullet. So that includes, for example, homeless children, children in the preceding 2 years who have participated in Head Start, and a few others here. And finally, it's important to note that poverty is not a criterion for eligibility for services. So to recap, eligibility for Title I services is based on where the student resides and the educationally related criteria established in consultation between the LEA and private schools, or can be based solely on the status of the student as applicable. So let's briefly go into two common scenarios related to eligibility for Title I equitable services. If an LEA has only K through 8 participating Title I public school attendance areas, but also has 9 through 12 private schools, only the K through 8 private school children would be eligible for services. And this is because of the residency requirement I described in the prior slide, that in order to be eligible for Title I services, a private school child needs to reside in a participating Title I public school attendance area And again, in this scenario, it would be the K-8 children who are identified as low achieving by the LEA in particular, who are eligible for services. Regarding the second bullet, it's also common for a private school child to reside in a participating Title I public school attendance area of one LEA, but attends a private school in a different LEA. In this scenario, firstly, it's important to note that the LEA in which the child resides is still responsible for providing Title I equitable services to the child, not the LEA where the private school is located. But the child is still eligible for services as long as the child is identified as low achieving or as one of the statuses listed in the prior slide. In this scenario as well, the LEA in which the child resides may arrange to have services provided by the LEA in which the private school is located and reimburse that LEA for costs. Sometimes, however, an LEA may not be aware of every instance in which a student who resides in a participating Title I public school attendance area attends a private school outside of the district. So this is why if a private school believes that it has students that may be eligible for Title I services because they reside in a participating Title I public school attendance area in a different LEA, and the private school hasn't been contacted by that LEA, it would be prudent for those private school officials to contact the LEA directly in order to ensure that their eligible students are considered for Title I services. We get questions pretty often regarding these types of situations, so we would encourage anyone to look at Section C of our Title I Part A Equitable Services non-regulatory guidance, which would serve as a really good resource for these questions. We have a link in the chat, and also we provide a link to that at the end. Okay, moving on to eligibility for Title VIII equitable services, and Janae touched upon this earlier, but to reiterate, unlike Title I equitable services, there is no residency requirement for ESEA programs covered under Title VIII. So for Title VIII covered programs, an LEA must provide equitable services based on the number and educational needs of children who are enrolled in private schools within the geographical area served by the LEA that want their eligible children and educators to participate, even if some of the children enrolled in the private schools reside in other districts or states. So a child's residency within the LEA is not a factor, but as Janae mentioned earlier, some covered programs like Title III Part A for English language learners, services can be restricted to only those children that meet the specific eligibility criteria of the program and their teachers. Also, in cases where there is limited funding and resources and the number of children who can participate in the program is limited, such as Title IV Part B, 21st Century Community Learning Centers, LEAs need to engage in timely and meaningful consultation with private school officials to determine which students will participate in the program. So although most children enrolled in private schools pay their tuition with private funds, there are some instances in which public funds may support a child's tuition, for example, through a federal or state scholarship or scholarship type program or a state education savings account. In the past, we've received questions regarding school choice as it relates to eligibility for equitable services. Participation in a federal or state private school choice program does not impact eligibility for ESEA equitable services. So regardless of the source of funds paying a private school child's tuition, the child is eligible for equitable services under the ESEA if the child meets the eligibility requirements of the respective program that was discussed in the previous slides. We also want to cover a few parameters that apply to both Title I Part A equitable services and also Title VIII equitable services. First, services and other benefits being provided by the LEA or a third-party contractor must be secular, neutral, and non-ideological. This is a specific requirement under the Elementary and Secondary Education Act. Also, federal regulations require that services must supplement and in no case supplant the services that would, in the absence of services provided under that program, be available to participating private school children. So in other words, an LEA must ensure that the equitable services it provides under covered programs supplement services a private school would otherwise provide and may not replace the education for participating children that the private school provides to all students. I also want to note that federal regulations require an LEA to use funds under covered programs to meet the identified educational needs of eligible private school children and not to meet the needs of the private school or the general needs of children in the private school. So in other words, for example, it would not be allowable for services to be designed to upgrade the entire educational program in a private school. Services must only be provided to eligible private school students. And finally, costs for services need to meet the cost principles in our federal regulations under 2 CFR Part 200. Specifically, costs need to be reasonable and necessary for the performance of the program in the view of a prudent person, and also be allocable to the program. So the LEA should be able to demonstrate that the costs for the different types of services are necessary and reasonable and support the purpose of a particular program. So switching gears now to the monitoring and enforcement of ESEA equitable services. And to help ensure equitable services and other benefits for eligible private school children, the ESEA requires a state educational agency to designate an ombudsman to monitor and enforce ESEA equitable services requirements for both Title I and Title VIII covered programs. So the ombudsman should be working with other SEA staff administering Title I and Title VIII covered programs to develop monitoring protocols that are applicable to the provision of equitable services under each program, and should take an active role in the monitoring process, particularly with respect to the resolution of any findings regarding equitable services requirements under Titles I and VIII. The ombudsman is really the SEA's primary point of contact for addressing questions and concerns from private school officials and LEAs regarding the provision of equitable services. We listed here some common examples of activities of the ombudsman in the second bullet. This will also include playing a role in responding to and resolving any complaints regarding equitable services that the SEA receives under its ESEA complaint procedures, which brings me to the final slide. So the ESEA has a specific complaint and appeal process available to private school officials or any interested party. Specifically, under the ESEA, private school officials or any interested party may file a formal complaint with the SEA if private school officials believes that timely and meaningful consultation has not occurred or that equitable services has not been provided. Federal regulations outline what must be included in a formal complaint, which is listed here in the second bullet. But when a complaint is filed, the ESEA affords the state 45 days to resolve the complaint. If the state doesn't resolve the complaint within 45 days, or if private school officials or the LEA is dissatisfied with the outcome of the SEA's resolution of the complaint, the state's resolution can be appealed to us at the Department of Education. And the appeal needs to be filed with us no later than 30 days following the state's resolution of the initial complaint, or within 30 days after the 45-day timeline that a state has to resolve the initial complaint ends. Sometimes, as part of its own ESEA complaint procedures, an SEA might require an intermediate step, like first filing a complaint with the LEA prior to the state addressing the complaint. But the state's procedures in these cases must still result in the state's final resolution of the complaint within 45 days of the initial filing of the complaint. So that covers those final two topics. And with that, I will turn it back to Janae.
Great. Thank you to Isadora, Mike, and ADL for walking us through what often feels like very complex requirements. We hope that the information we've presented today has deepened your understanding of ESEA equitable services. And if you haven't already, we definitely encourage you to review the non-regulatory guidance for Title I and Title VIII, noting that the Title VIII guidance does include sections specific to each Title VIII covered program. You can also find a large collection of other resources related to the ESEA and equitable services on OMPE's ESEA page, which we also have linked here on this slide, and we've posted all of these links in the chat. And now I think we have just a few moments that we might be able to take a deeper dive into a few of the questions that have been posed in the chat. And for that, I'm actually going to invite the Director of the Office of Non-Public Education, Maureen Dowling, to turn her camera and mic on. And I think she's been keeping an eye on that chat and can share with us a few of the issues that have bubbled up there that that may be worth a little more of our time today. And again, if we don't get to your question, if your question was not addressed in the chat, you can reach out to us via email following the webinar to receive some technical assistance on your specific question. So, Maureen? I think you're still on mute.
Hello, everyone. My name is Maureen Dowling, and I'm the Director of the Office of Non-Public Education at the U.S. Department of Education. And I want to just start by thanking you. I know we have many private school and public school leaders and officials at the state and LEA level with us today. So thank you for taking the time, and also my colleagues in providing such good technical assistance. I know one of the questions we had was, what if your state does not have an ombudsman? So I'm wondering if one of our colleagues here could just address maybe some steps that a private school official might take kind of to proceed through that particular process if they're aware that their state perhaps has not yet designated an ombudsman, or they have maybe left and they haven't been replaced.
So this is Adil Duran with, I think in these cases, oftentimes states have someone designated to administer a specific program. So they might have a Title I contact or a Title II contact. While the state might be working to designate an ombudsman, that individual might be a good person to contact in the meantime with general questions related to equitable services.
Great. And what I would just add on to that too, if at any time, there are issues, certainly reaching out to your state Department of Education regarding this matter. And if for whatever reason, maybe the answer isn't forthcoming, please feel free to reach out to the Office of Non-Public Education or to the Title I office, because we are always happy to assist you in facilitating that communication with your state. Another question we had in the chat room had to do with the proportional share and determining the proportional share, and whether one could take relative need into consideration when it comes to determining the proportional share. And I wonder if Mike would like to respond to that, or I know anyone else on the team.
Sure. I mean, the statute requires that an LEA factor in the number and needs of private school children when determining the proportional share for Title VIII covered programs. As I mentioned, in many cases with Title VIII, the LEA really assumes that the needs are commensurate with the numbers. And I think that it's really dependent upon the specific facts of the program in terms of how that need component is actually factored in when determining the allocations. And so it's hard to answer how the need element is actually applied. I gave the one example of Project Serve, and where there is a particular school that has been more affected than others by a traumatic event. So I think that again, beyond that example, I think we need to know specific facts and what might be a district might be considering in order to be able to answer that. Although, if my other colleagues have other ideas, I'd welcome them to weigh in as well.
Yeah, in general, I'll just add on to that, Mike. I believe facts are always very important. That when you're looking at the needs of the individual students, that certainly comes into play once you've determined the amount of funding available, and then looking at some students and perhaps students in certain schools, there may be a greater need, particularly if you are pooling. there may be more funding, more Title I funds that are going to be used for students in a particular school because of their needs, even if that school, under a pooling situation, didn't generate the amount of funds that are going to be expended for such students. But again, if there's any specificity you would like to send us in regarding to that question so we can look at it very thoroughly and respond to you, we'd be happy to. I think I'm going to need to stop now. I'm going to turn it back over to Janae to close us out.
Yes, thank you, Maureen. And as Maureen mentioned, for many of the questions, there may be some specifics and nuances that would be helpful in better understanding the circumstances around those questions. So please do feel free to reach out and submit your questions to us via email if they were not answered today. And I know there's been a lot of questions about access to the slide deck and a recording. And yes, we have been recording, and we will make the recording available as soon as possible. It does take a little bit of time just to transition it, get the editing done and posted. And we will also provide the slide deck when we're able to provide the recording. So I apologize, it's not available on demand today, but we will be able to get that out to you. So knowing we're at time now, I want to thank everyone for joining us today. It was really great to see such a large turnout for this. And thank you to our colleagues in OESE and OGC for supporting us in this webinar and in all the other work that we do together. We hope everyone has a great afternoon.